So yes, I just had to end that video and start a new one because we are proceeding to a new topic. So the next important. Before I proceed, did you guys understand what I was trying to explain? Any confusion there? Are you guys there?
Sir, why Bentham was against customary law as such? Because customary.
See, the thing is that customary laws also vary from one place to another. Okay, and there is no, the thing is that for both these thinkers, if you see, okay, Austin and Bentham, okay, what do they say? That laws are possible when there is a sovereign, okay, and when there is a sovereign, there is an expression of sovereign's will. That's what law is, okay. So there has to be some kind of, you know, uh, direction of law from from one superior to some kind of inferior, okay. But in case of customary law, where does it come from? No one knows where it comes from. We assume that it emerges within the community. Okay, who is it applicable to? To every member of that community. Okay, so he does not think that it is proper law. Okay, for law to be there, he thinks that okay, ultimately. What do you call it? A political sovereign has to be there. But for customary laws, okay, you may call it law, but it's not the kind of law that he is trying to define. Okay, and if you are asking me personally, okay, my idea, my take on that will be, yeah, customary laws are fine. I mean, yeah, quite often they emerge because they reflect some of the best ways of doing things within a society, to that extent that it does not go in conflict with certain other higher principles, fine. But if they do come in conflict with certain principles, higher principles, for example your human rights, okay, then yeah, customs will not have the validity. Okay, so only to the extent that they are not in conflict with certain higher ideals do they have validity. That's my position though. But for Bentham, it was for a completely different reason, that you need a sovereign, whereas in case of customs, where is the sovereign? Okay, so he as you have probably seen, there's a quotation there, okay, where he says, uh, written law is the law for civilized nations. Okay, traditionary law for barbarians and customary law for brutes. Okay, so yeah, and that's his view on customary law. So I hope that is clear, that it just does not fit into his definition that he gives. So anyways, so now let's proceed to the next important thinker, okay, the person who's credited as being the father of positive jurisprudence. But by now you know that Bentham had written about positive law, okay, almost 50 years before Austin had written about it. But it came to light only later. That's why we credit Austin as the father of jurisprudence, positive jurisprudence to be more specific. Now, anyway, Austin inherited a lot from Bentham because he was his neighbor, so he got to learn a lot from him. He's also a utilitarian thinker, and his reason and justification for positivism comes from his belief in utilitarianism. Okay, so and they both are what we call them as fact positivists or hard positivists. Okay, and the ones that we study later, for example, your H.L. Hart, okay, is considered as normative positivism and also known as soft positivist. Okay. Now the important book, okay, which was written by John Austin, okay, is by the name Province of Jurisprudence Determined. Okay. Whereas the other book of Laws in General, okay, also known as The Limits of Law Defined, okay, and his book, as you can see, more or less the same kind, okay, The Province of Jurisprudence Determined, okay. So this was written almost 50 years after Bentham's Of Laws in General, but it's just that Of Laws in General was discovered much later, okay. Now, as I told you, his Austin's work, again, is very interesting. Okay, so it was in fact one of the most dominant theories of jurisprudence in the 19th century. Okay, and he did not himself write any book. Okay, I mean, it was essentially a set of lectures. Okay, 10 lectures that he had delivered at University of London. Okay, but as is the case with most jurisprudence teachers, okay, he lost his audience very soon. Okay, so yeah, he had to discontinue. Okay, but later on it was compiled into a book. Okay, so it's a very interesting book. Okay, very interesting. You might not like. Okay, so that book is nothing but compilation of all the lectures which failed to draw crowd, but later on became a very important work on jurisprudence. Okay, so yes, Austin was a positivist. Of course, he's known as the father of positivism, to be more specific. Fact positivism. Okay, and he's also trying to give you a definition of positivism based on his idea of utilitarianism itself. Okay, that you need positive law because that's the best way to increase greater good for greater number. Okay, so he essentially does the same thing as Bentham does, but his approach is little different from Bentham's. Okay, so yes, he restricts the province of jurisprudence to what he calls positive laws. Okay, laws which are made by a human sovereign. Okay, a determinate a human sovereign who's a determinate human superior. Okay, so yes, for Bentham, as you know, the scriptural laws, I mean, they existed. They probably affected indirectly. Okay, but they did not mean much to Bentham, because ultimately, if you were to come to conclusion about what is right and what is wrong, you will do that through principle of utilitarianism. Okay, but unlike him, okay, for Austin, the law of God, okay, just like if you remember Aquinas, okay, at least for Austin, the reveals what is revealed in the scripture, the God's laws as is revealed through the scriptures, are a very important source of laws. Okay, and laws properly so called. Okay, although they are not positive laws. Okay, they are moral rules, but they are nonetheless, okay, for him, laws properly so called. It's just that they are not concern of jurisprudence prudent. Okay, so what is the concern of a jurisprudent? Okay, the concern of jurisprudent will be laws which are made by sovereign. Okay, that is positive law. And the other law, that is God-given law as is revealed through scriptures. Okay, they are concerned of a moral thinker maybe. Okay, moral philosopher maybe. Okay, but they are laws properly so called. So he gives higher importance to the laws as revealed through texts. Okay, scriptures, unlike Bentham. Okay, so yeah, here you see the similarity between Austin and Aquinas. Okay, but here's the distinction between Austin and Aquinas. Okay, so the laws of God, okay, is found in scriptures, which are known as lex. What was it? You had lex eterna, lex naturalis, lex scripta, and lex humana. Okay, so
lex
you had
divina.
so yes, lex divina, huh? So yes, I forgot the Latin name. So yes, when he's talking about lex divina, that's what he's referring to. Okay, so the ones which are revealed through scriptures. Okay, those are the laws properly so called. Okay, now God's laws are not comprehensively divine through the scriptures. Okay, there are other laws as well. Okay, so that you identify how, by applying your reason. Okay, now that portion, okay, that you derive by applying your reason, okay, is not laws properly so called. Okay, they are not laws properly so called. They are moral rules, so they can at the most be laws improperly so called. Okay, they are not laws properly so called. Okay, so yes, Now, why would God's law be laws properly so called? At the end of the day, God's laws are laws properly so called because God wills the greatest happiness of all the creatures. Okay, and principle of utility, okay, essentially leads you to that, and essential. So the scriptures are essentially for that purpose. So yes, that is why it is laws properly so called. So yes, his ultimately his justification for what do you call it? Uh, why is it that God's laws are laws properly so called? It's essentially comes from certain authority. So God is an authority. Okay. On the other hand, human-made laws, okay, man-made laws or positive laws, okay, positive laws, okay, what our philosopher Aquinas calls as lex humana, sorry. That is the positive law, okay. That is also law properly so called because it comes from definite authority. So authority is the justification for you to call something as laws properly so called. Okay, so that's essentially the idea. So I hope this is clear why he calls the first two kinds of laws properly so called and others not so much. So as you can probably know by now, he thinks that international law, constitutional law, or customary laws, okay, or other practices, household practices, or etiquettes, etc., social etiquettes, whatever are there, okay, they are not laws properly so called. Okay, they are laws improperly so called. Okay. So I hope this distinction is clear to you guys. Laws properly so called and laws improperly so called. Is it clear?
Yes.
Okay.
Yes, sir. Yes, sir.
Mm-hmm. So yes, so the proper sphere of jurisprudence. Okay, so what does jurisprudence concern itself with? He says that jurisprudence concerns itself with only positive law. Now, why does he think that jurisprudence concerns itself with only positive law? Okay, why should a jurisprudence be not concerned with divine law? He does not give us any more reason than the fact that okay, it comes from human authority. That's it. Okay, that's the concern of jurisprudence. Okay. So yes, we are to separate positive laws, which is the concern of jurisprudence, from the law of God, from the law of morality, from the norms of association, etiquette, social behavior, laws, okay, the rules of your household, international law, and constitutional law. All those are not concern of jurisprudence. Okay, only concern of jurisprudence is positive law. Okay. So there will be essentially laws improperly so called. Okay, so yes, he recognizes only two authority. One is the human authority, and the other one is the Christian authority of the Christian God. Okay. So yes, laws properly called. What are laws properly called? For him, laws properly so called are general commands. Okay, they are general commands which are made by the sovereign. Okay. So we will go into greater details of what is that when we look at the definition given by him tomorrow. But today, before we end, I would like to discuss one thing that differentiates, that distinguishes, our philosopher John Austin here from that of Bentham. Okay. Now, unlike Austin, Bentham did not think that common law is not a proper law. Okay. So when he talks about law properly so called, common law is very much part of that law properly so called. Okay. Now, how is he able to do that? Obviously, common law is not created by the sovereign itself. Okay, but those are judge-made laws. Okay, then how can he say that common law is law properly so called? Okay, his answer is very simple. Okay. So judges are authorized here, okay, authorized by the sovereign itself to adjudicate disputes, okay, and they will adjudicate dispute, but where there is a gap in the law, okay, they do not then refer back to the legislators. So in such case, the judges have been authorized to create a rule when there is a necessity of a rule, okay. So that's the position which is taken by Austin, whereas Bentham will not be okay with it. Okay. Now, why do they come to different conclusion about this? It's quite simple, okay? They used utilitarianism itself, okay? So for Bentham, his utilitarian logic led him to the conclusion that when judges make laws, okay, those are the worst laws, okay, they cannot be in fulfillment of the principle of utilitarianism. But for Austin, he came to a different conclusion. For him, he says that some of the best laws, okay, out there are creation of the judges, okay. So it's Austin's utilitarianism, okay, that led him to the opposite conclusion that judicial, lawmaking is not only inevitable, but it is unambiguous public good. So it is one of the best laws that you will come across. Okay, so it's applying the same logic. They came to completely different conclusion. So as you can see, as from your hindsight, from all the developments that you see around you, and how successful common law legal systems have been. Okay, you you can say that probably Austin was right in that sense. Okay, although we have to admit that there are defects. However, apart from all those defects, I think Austin has come to a better conclusion about common law than Bentham did. So anyway, so here's the remark that he had made, okay, a criticism that he had directed against Bentham regarding his position on common law. He says, Austin says, I cannot understand how any person who has considered the subject can suppose that society could possibly go on if judges had not legislated, or that there is any danger whatsoever in allowing that power which they have in fact exercised to make up for the negligence or incapacity of the avowed legislator. That part of the law of every country which was made by the judges has been far better made than that part which consists of statutes enacted by the legislature. So as you can see from this quote, his admiration for common law, that it is in fact one of the best laws, okay, which is there. So he does not agree with Bentham that judge-made laws are the worst ones, okay. So, and why does he say so? It's not just because they are the best laws. It's also because of his another understanding that judges are kind of delegated legislators when there is a gap in the law. Okay, so that's the position of Austin with respect to judge-made laws. So sorry, there's something going on. So I'll end my discussion for today. Let's meet in the next class for our discussion subsequently.